Well, welcome. Thank you everyone for being with us. My name is Beth Gelman. I am the Senior Director of Arts and Cultural Programming here at Creative Pinellas. And we were just so thrilled to be able to host the Path to Unity exhibit, and very excited that this wonderful program with these fabulous people is here on our campus. So thank you so much for being with us, whether you are here in our classroom or whether you are watching it virtually. Thank you so much for being with us. I'm going to do a very short introduction of the people who are involved in this, and then I will turn it over to people who are much smarter than I am, certainly about this subject. So we're going to start with our, I'm going to say our guest of honor, and that is a seasoned trial lawyer of nearly 40 years, a super lawyer for the past consecutive 15, and AV preeminent even longer. We are so delighted to have Larry Smith here with us. Larry focuses his practice in the areas of complex, high-exposure cases for clients, including domestic and international product manufacturers, airports, and other claims involving personal injury and wrongful death cases. Larry has been certified as a Supreme Court of Florida Circuit Civil Mediator since 2018 and a Florida Supreme Court Arbitrator since 2019. On the diversity, equity, and inclusion front, Larry was the first openly LGBTQ attorney to address the Florida bar about sexual orientation and its role in professionalism and DEI efforts. He was the first openly LGBTQ chair of the Florida bar's Equal Opportunity in Law section and was an inaugural and current member of the Standing Committee on Diversity and Inclusion, where he holds a leadership role. For all his efforts, Larry has received a number of awards that go on for pages. So I am going to really invite you to Google Larry, but he has won so many. Not only is Larry the first openly LGBTQ attorney to receive any of these awards, I need to say some of them, Larry, I'm sorry. So the Federation of Defense and Corporate Counsel's Diversity Award, the Orlando Business Journal's Lifetime Award, Litigation Council of America and Diversity Laws Institute Diversities Award, the Florida Bar G. Kirk Huss Humanitarian Award. I mean, these are amazing. It goes on. So Larry was the first openly LGBTQ attorney to receive any of the awards and the only person to receive all of them. He continues to write, speak, and coach about the importance of diversity, equity, inclusion, and belonging. And thank you for being here to do that. Next to Larry is my friend, attorney Jacqueline Hubbard. Jacqueline got her degree, her law degree, from Boston University, where she was the very first recipient of the Martin Luther King Jr. Fellowship for the Study of Law. She was the first black female city attorney in Florida, in Fort Myers, and she was the first boy, I can't read what I wrote here, but she is right now, I know, the president of ASALA in St. Pete. That's the Association for the Study of African American Life and History. And she says, I think one of her most proudest accomplishments is her daughter is a published author with a PhD and 3 published books, so that's pretty amazing. Wow. Next to her is my friend, Judge Charles E. Williams, who is an alumni of Howard University in Washington, D.C. He earned his law degree from the University of Florida. He is a circuit court judge in the 12th Judicial Circuit of Florida. He did not want me to tell all his awards because the truth is they also go for pages, but I'm going to tell a couple of them. Community Service Award from the Manatee County Board and the Manatee County NAACP Public Service Award. He has received awards in Sarasota and all over our fair state and further And he is, I think, one of the most highly sought after board members, because every time I go to a new board, there is Judge Charles, so thank you. I am going to turn this over to Judge Williams, and I'm going to ask Starlet Massey if she would come up and assist over here with the PowerPoint. I need to say, can I say this, that that we are so excited that it is here, that I just want to give my huge thanks to Starlet Massey and Kylene Hinkle for bringing this to us and allowing us to showcase this marvelous exhibition.
Thank you. Thank you to Beth and Barbara St. Clair and Creative Pinellas for having us, and especially to the three of you for your time and being here today. And a special thanks to Charlie Ann Cyprit, who created this program out of thin air and a lot of passion for this cause. And I'd also like to include Miss Arnell Bryant Willis, who is here all the way from Tallahassee. Thank you so much for being here.
Okay.
All right, Judge Williams.
And we're going to have sort of a slide presentation, and the first slide is the description, really, of this event, which is the Path to Unity, celebrating Florida legends. So if we could go to the second slide, one of the key components of this Path to Unity program is what we try to do in terms of educate young people. And so it's very important for us to reach out into our local communities and talk to students, particularly middle and high school students, about not only the importance of the law, but how the law has shaped our society from the beginning, from decisions that were made by the United States Supreme Court to the role that lawyers had in social justice and social reform. So what you'll see is basically a timeline of what we try to incorporate in our Path to Unity project, especially the educational component. And it's a basic timeline. I'm not going to spend too much time on it, but when we talk to students, we want people to understand, these students to understand the context of the law over history and how it shaped the United States. So we start talking to them about the ratification of the Constitution and the Bill of Rights. We talk to them about the first significant U.S. Supreme Court's opinion which dealt with race in this country, which was the Dred Scott decision. In 1857, a very, very woeful decision by the United States Supreme Court basically determined that members of this country who were of African descent were not citizens in this country. We do talk about the Civil War, how the Civil War was shaped not only by the Dred Scott decision, but about issues of slavery and emancipation and how that played a role in the Civil War. We go on to talk about the Emancipation Proclamation, the 13th Amendment, and then there's a second case that came, the Plessy versus Ferguson decision in 1896, which basically looked at Dred Scott, did determine that African Americans were citizens, however, they could be treated separately. And so the Plessy decision sort of shaped the civil rights movement. It was the decision that basically legalized Jim Crow laws and remained the law until 1954 in Brown v. Board. So when we talk about the Path to Unity and we talk about it in terms of the law and the legal profession, we take a look at it in those contexts. As Martin Luther King Jr. stated, the arc of the moral universe is long, but it bends towards justice. Florida has its own rich history of civil rights leaders who have shaped the legal landscape. The Florida Bar, which oversees all lawyers in this state, is honoring a diverse group of local legal pioneers who are part of this rich history by giving visibility to their legacies and impact on civil rights. And we're joined by one of those tonight. The Path to Unity program is the story of these pioneering attorneys as they bend this long arc toward justice right here at home. The Path to Unity is the story of the Florida Bar. And if we could go to slide 3. What you see on slide 3 is Attorney James Weldon Johnson. The world that existed between 1896, the year Plessy was decided, and the year 1954, when Brown versus Board of Education was decided, was the world of Attorney James Weldon Johnson. Johnson was a lawyer, writer, diplomat, social critic, and civil rights advocate. He was born in Jacksonville, Florida on June 17, 1871. And in researching James Weldon Johnson, he was, by all accounts, the definition of a Renaissance man. He was a poet. He was appointed as U.S. Consul to Venezuela and served from 1906 to 1913. He was the first black professor to be hired at NYU. He was a professor of creative literature and writing at Fisk University, and at the age of 16 enrolled at Atlanta University, a historically black college. He became a lawyer, writer, diplomat, social critic, and civil rights advocate. He was instilled with the value of education by his father, a waiter, and his mother, a teacher. Johnson excelled at the Stanton School in Jacksonville, and ironically, the Stanton School is still in existence. It is considered by many to be the first school exclusively for the education of African American young people. There is a little bit of a dispute. There may be a second school that's taking that title, but certainly it was one of the first two schools in the state of Florida that was established after the Civil War strictly for the education of African American youth. Again, as I told you, in 1889 he entered Atlanta University in Georgia and he graduated in 1894. In 1896, Johnson began to study law in Thomas Ledwith's law office in Jacksonville, Florida. In 1898, Ledwith considered Johnson ready to take the Florida bar exam. After a grueling 2-hour exam, Johnson was given a pass and admitted to the Florida bar. One examiner left the room stating, "I'll be damned if I stay here to see him admitted." So in 1898, Johnson became one of only a handful of black attorneys in the state of Florida. If you could turn to slide 4. Of all his many achievements, you may already be familiar with the song, "Lift Every Voice and Sing." It is indeed a poem written by Johnson in 1900 to music written by his brother, John Rosamond Johnson. It was first performed as a poem as part of a celebration of Abraham Lincoln's birthday. It is a song of liberation, pride, faith, and love. It is well known throughout the country and often referred to as the Black National Anthem. Although it was written over 100 years ago, it is still sung today at various settings, including the inauguration ceremony for the first African American president of the Florida Bar, Eugene Pettis, in 2013. In 2020, in the wake of George Floyd and other acts of social justice and the acknowledgement of social justice concerns, the NFL decided to play it before all of its games. If you go to slide 5. Although personally and professionally still subject to the law of Plessy versus Ferguson, Johnson became one of a long line of distinguished African American lawyers in the state. Many of these lawyers were the first in their careers and their professions. These include Henry S. Harmon, the first black lawyer admitted to practice in the state of Florida. Henry Harmon has an interesting story in and of himself. He fought in the Civil War. He was stationed in what is now Gainesville, Florida. And during Reconstruction, he was appointed the voting registrar in Alachua County. He also won a seat on the State House of Representatives, serving until 1870. In 1869, he applied to the Circuit Court to be admitted to the Florida Bar. And so we also have Josiah Thomas Walls, Florida's only Reconstruction-era black congressman. Josiah Walls was also a law partner to Henry Harmon. And he was a U.S. congressman who served, again, 3 terms in the U.S. Congress during Reconstruction. He was born in Winchester, Virginia, worked as a slave, actually, for the Confederate Army during the Civil War, and he was captured as contraband, and he was discharged in Alachua County, which is how he ended up in Florida. We also celebrate the legacy of James Dean. He's revered as Florida's first black judge elected in the South after Reconstruction. In 1888, he was removed because he allegedly married an interracial couple. He was chased out of the Keys. Jeb Bush, governor of Florida, reinstated him posthumously in 2002. We also celebrate the legacy of Joseph Hatchett, who was appointed to the Florida Supreme Court in 1975 as the first black jurist appointed to the highest court of any southern state since Reconstruction. We also celebrate Peggy Quince. In 2008, she was named the Chief Justice of the Florida Supreme Court, becoming the first black woman to head the highest court in the state of Florida. If you could go to slide 6. As you see in slide 6, segregation in public schools was ended by Brown v. Board of Education. In 1954, the Supreme Court overturned Plessy, and as you learned, this case overturned Plessy's separate but equal decision. However, this case did not immediately overturn Plessy. Instead of requiring immediate action, it required all deliberate speed. And this was up to the interpretation by many critics as basically allowing the South to take as much time in integrating schools. What I'd like to do is, I'm going to ask my sister, because I came on the end of legalized segregation of the schools in Pinellas County, where we sit, but you actually attended some of those segregated schools. And I was wondering, Jacqueline, if you could sort of reflect on not only your experience attending those schools, but the impact of Brown, if it had any impact on you in terms of your education.
Right. Now, my education was a segregated education. And I was very happy in that environment. In fact, my mother was a school teacher at the school that I attended, and my father was a teacher in Roanoke Rapids, North Carolina, which was close to Weldon, this little town where I grew up. Every morning we would sing James Weldon Johnson's Negro National Anthem before classes started. We'd all assemble down in the area in front of the school. We had a very pretty little brick school. And after we sang that anthem, we would disperse and go to our classrooms. Now, all of our teachers were African American. All of the administrators were African American. Everybody that meant anything to me as I was growing up was an African American. My dentist, my doctor. In fact, our family doctor went to medical school with my grandfather, and my grandfather graduated from medical school in 1905. So it was a segregated world, but it was not a deprived kind of world. It was a little closed-in world where you were protected from the slings and arrows of racist and segregation. And you were taught various things to protect yourself from harm should you encounter people who were very racist and as my mother would say, crazy. I said, oh, okay. So I enjoyed my primary and elementary school education in North Carolina, and I loved my teachers. I remember my first grade teacher, Mrs. Cook, who lived around the corner from us, and she loved the way I spelled because I could read when I was in the first grade because my dad taught me. That's how I fended off my brothers. If my brother hurt my feelings, my dad would call him over and say, okay, stand right there. And he said, Jackie, read to your brother. And I would read to my brother, and my dad would tell him, you should know better than to insult someone who can read better than you can. So it was a good practice. And when I graduated from the 8th grade, I was the valedictorian of my 8th grade class, and my parents, as soon as I finished my little speech, we piled in the car and drove to Florida. And Charles was in the car. And we got here in 1961. In 1961, the junior high school that I attended on 16th Street South was segregated. My mother taught the 6th grade there. She taught me in the 6th grade in North Carolina also. And it was very similar. to what I had experienced in North Carolina, only in a larger town.
Effectively, the schools in Pinellas County didn't effectively begin the integration process until the late 60s, early 70s.
That's correct.
And let me ask Larry, because I want to get his perspective, and I'm not sure what the school system was like when you were growing up. You may have come in on the vestiges of segregated schools, but again, the impact of Brown v. Board in terms of integrating the school systems that you attended, if you have some reflections on that.
Well, I'm so young, Charles.
I recognize that.
But I've read stories. Now, my school, my public school, I grew up in northwestern Alabama, and my public school was integrated when I think I was in the 7th grade, and we moved into a middle school setting, and one of my best friends throughout until we graduated from high school and then went to college was one of the first African American guys that I learned to be friends with in this new environment, because I was making new friends in middle school just like everybody else was. Some people, their friends kind of came along with them, but I guess middle school was an opportunity to meet new people, both because there was a bigger geographic pull, but also because of integration. There were other people coming in. And after that, in fact, I think, boy, you're pulling memories back. The school, when they moved us into a middle school setting, it was the old African American school that had been closed because of segregation. And so I was actually going to what had previously been an all-black school. So I was kind of the visitor in some ways. And so, and then after that, of course, nothing is easy. It was still difficult and painful, and it was there, and it's there today. But I actually remember making friends and thinking what a wonderful opportunity it was.
Yeah, and I'm a little younger, I think, than both of you. But
Wait.
The schools in
You're a judge. You know.
I know. But the schools in Pinellas County where we're holding this seminar, this talk, I remember being bused in 1975. And effectively, that was really, there had been pockets of integration in some of the schools here locally, but there wasn't a concerted effort, and that was probably because of a federal mandate that took place until about the mid-70s. So I came in on the end of that. If we could go to slide 7. So we do know that Brown v. Board, the dicta in that opinion, by all deliberate speed, caused many communities in the South, especially, but in the North and the West, to take their time and were very reluctant. But Florida was unique in that some of the protests, many of the protests, revolved around Florida's beaches. And in slide 7, what you see is a picture of what is, I believe, Lido Beach in Sarasota. In many waterfront communities in Florida, the flashpoint for integration of public facilities was the beaches. In 1955, a group of 100 African Americans formed beach caravans to drive out to Lido Beach in Sarasota, where they waded into the water in their good Sunday clothes. They endured bricks thrown at them, epithets, and more. And just to expand on this photograph, since I live and work in Sarasota, the history of integration post-Brown is pretty much reflected in that photograph. Emboldened by the Brown decision, knowing that separate beaches was wrong, in Sarasota County there was a beach towards where is now Venice, where blacks exclusively were told that was your beach. And so what the citizens of Sarasota did was basically every Sunday after church, they would get into their cars and they would drive out to Lido Beach to integrate the beaches out there. The resistance was not as hostile as it was in other parts of the state of Florida, but it was hostile just the same. The town of Longboat Key, thinking that perhaps, which is not far from Lido Beach and was at the time a part of the city of Sarasota, decided that they might be targeted to be the beach that will have to integrate. So what they did, they separated from the city of Sarasota and became their own community, the town along Boat Key. So that's how they dealt with that issue. But beach caravans were the way that the African American community in Sarasota reacted. They were relatively peaceful. If you go to Sarasota now, towards Lido Beach, you will see a marker which commemorates what these brave people did to integrate the beaches of Sarasota. But it was not confined just to Sarasota. If you go to slide 8, what you see in slide 8 is an incident that occurred actually in St. Augustine. St. Augustine, if you followed Martin Luther King post-Montgomery bus boycott and prior to Selma, it was a very difficult period of the civil rights movement. One of the targeted communities for Dr. King was St. Augustine. St. Augustine, Florida, was like many communities in the South, extremely segregated. However, the citizens, the African American citizens, and other citizens who cared about the African American community thought that this would be a perfect place for Dr. King to come. And so they decided that they were going to integrate St. Augustine Beach. And as you can see from this photograph, this is what happened. There's also a very famous photograph that's not part of the slide presentation that many of you recall, in which there were African American young people in a pool.
Right.
And the motel manager where the pool was located was pouring acid in the pool. That was St. Augustine. And Dr. King actually came down, attempted to mediate with the city of St. Augustine. Ultimately, it did not work, and he left St. Augustine. So St. Augustine was actually a town that even Dr. King could not sway. But this is what you saw. Here in Pinellas, Spa Beach in St. Petersburg was a whites-only beach, despite technically being open to the public. In 1955, here locally in Pinellas County, a group of black and white civil rights activists attempted to go to Spa Beach. They were not allowed and were redirected to what is now Demon's Landing in St. Petersburg. So that's where the segregation was as far as the beaches. Dr. Fred Alsop and others filed and won a lawsuit against the city of St. Petersburg. However, city workers, and this was to open a pool, not the beach. However, city workers would close the pool when blacks tried to swim. So it was not until 1959 that the pool and Spa Beach were finally integrated. So I know that, Jackie, you lived in St. Petersburg a little after that. What's your recollection about the beaches and the pools and the recreational situation around this period?
My recollection is that I did not ever attempt to go to a public pool, and none of my friends did either. But a lot of my friends' families had swimming pools, and so we would go to their houses to swim. One of those houses that I frequented was the house of Dr. Alsop.
Dr. Wimbush.
Dr. Wimbush. Dr. Wimbush had a nice pool not far from where I lived, and he had pool parties for us all the time. He was quite the civil rights activist. However, so I didn't participate in the integration of the public pools because I didn't go to I wouldn't have gone anyway, probably if they had been integrated. But that was just me. I was aware of it, and I can tell you that I was personally affected by the Civil Rights Act of 1964, because in 1964, the public schools in Pinellas County felt obligated to integrate. It's very interesting how they did that. They actually went to the black schools and picked out certain students to integrate certain white schools. And I was one of the people that was picked out to integrate one of the high schools. And my parents asked me, and this was my senior year in high school, did I want to, integrate and go to the white high school, and I said, no, I want to graduate from high school with my friends.
And
they
for,
thought-
and for the record, that was Gibbs High School. Gibbs High School was the school for African American students in St. Petersburg, established obviously during segregation. It's still there, but Gibbs, where you graduated and a couple of our siblings graduated from, was the segregated black high school in Pinellas County, in St. Pete.
Correct. And so I stayed there and graduated.
Okay. Going back to some of the things that occurred in Pinellas County, we saw the examples of protests, but in Pinellas County, specifically St. Pete, beach integration again was a flashpoint. I can recall that in Fort DeSoto Park, the north end was reserved for whites, and the south end was reserved for blacks. Now, this was still the case
Right.
in the 70s,
That's right.
although it was unofficial. It was not an official segregation, but the traditions from when those beaches were segregated were still in effect, even when I was in high school. And so by custom, you would go to the south end or the north end.
And may I say something?
Mm-hmm.
The South End, that's where black people tend to go now. And
Yeah.
it's really the nicest part of Fort DeSoto Park.
Right. Ironically, it was the nicest part of the beach, that part. Larry, did you have any incidents in terms of what we saw here in your communities, in terms of resistance or things that, looking back, you might have said, wow, how could that have happened where I lived?
No, I grew up in a really, really small rural community in northwestern Alabama, and I grew up on a little farm. I mean, I couldn't yell at anybody, and anybody hear me, much less fight with me about it. So I didn't have that. I guess what I did have was I was very aware that people in my community routinely expected African Americans to avert their eyes if they met on a sidewalk. I grew up hearing the N-word. So even though I didn't sense a clash, like a physical clash, I sensed the feeling of apartness. And that was true from when I was young and, well, still to some extent. But certainly, and I should say, certainly not in the way that African Americans felt it. I mean, physical beatings, terrible things happened. I didn't see that or sense that. I'd like to believe as I got older that I would have been courageous enough to have said something and at least get a black eye out of it or something, but I didn't.
There were a lot of, we have the beach protests because obviously Florida is known for its beaches, and some of the most iconic civil rights scenes you'll see in Florida are from attempts to integrate the beaches. But coming back here locally in Pinellas County, I think we do have to acknowledge some of the things that occurred here, specifically in the town that I grew up, or the city that I grew up in St. Petersburg. In addition to the beach integration issues, there was many other incidents here in Pinellas County that are of historical significance. And there were local icons, many of them attorneys. One who actually swore me in and became a judge on the 2nd District Court of Appeal, Attorney James Sanderlin. He was a very pivotal person here in this community. Judge Sanderlin, Judge Frank White, Attorneys Morris Milton, Attorney Ike Williams, Attorney Frank Peterman, all of them were, by just the fact that they were black attorneys, were civil rights attorneys here in Pinellas County. So in addition, we have the beach integration. We also had a very famous sanitation worker strike, not as famous as the one in Memphis, but quite as intense. That was mediated by attorney, soon to be Judge Jim Sanderlin. Not far from here used to be a golf course called Airco Golf Course. And I remember it because it was the first golf course I'd actually ever seen as a young person growing up. But it was totally segregated. And there was a famous civil rights leader who was a local doctor, Dr. Fred Alsop, who was a golfer, who tried to integrate Airco, and Airco resisted. So there was a lawsuit. Interestingly enough, I believe Airco was owned by the county, not a particular city, but to get around having the county endorse segregation, they sort of allowed a private company to manage the golf course, and thought that the private company, if they have a segregation policy, the county's not liable for it. Well, the courts didn't agree with that. So Airco was eventually integrated. There was also a very famous incident. I'm going to let my sister Jackie talk about it, because she not only knows about the incident, she knows the person that was involved in it. There was a mural in City Hall in St. Petersburg that was very offensive to African Americans who lived in the city of St. Petersburg. And a person at the time named Joe Waller actually demanded that the mural be removed. And Jackie, if you could just sort of tell that incident before we move on to our next slide.
All right, and Joe Waller repeatedly asked the city to remove the mural because it was offensive to African Americans. They refused, and so he went and ripped it off the wall and was arrested, of course. And there was quite a, I wouldn't say a riot, but there was quite a disturbance in the black neighborhood after that happened. And he was eventually released from custody, and his attorney was from South Florida. I'm trying to think of what his name is.
Yeah, I can't remember. But he actually did end up going to prison, though. He was sentenced ultimately, I think 5 years in prison. He served 22 months.
22 months.
And the mural, it was a minstrel show, basically all of the stereotypical depictions of African Americans, and it was right behind where the city council met. And
Right.
he actually physically
Ripped it off.
and was running down the street with it when they caught him. And it's sort of a civil rights legend in the city of St. Petersburg and Pinellas County. But individual acts like that occurred in communities all over the country. But these people were represented by lawyers, some white, mostly lawyers who had a conscience and needed to make certain that people's rights were represented properly. And so that occurred right here locally. So that's just an example. Now let's go to slide 9, which is the Civil Rights Act of 1964. What you see there is a very iconic photograph. As you can see, this is President Lyndon Johnson in 1964 signing the Civil Rights Act of 1964. Through this bill, the legislative branch of our government basically turned the Brown decision from legal precedent to statutory law. It outlawed discrimination in public accommodations, education, voting, and government-funded programs based on race, religion, sex, or national origin. Most legal scholars say that the Civil Rights Act of 1964 gave teeth to all of the amendments, all of the race amendments, and one historian says that it was the last shot fired in the Civil War. So the Civil Rights Act of 1964 led to a variety of different acts, but it's sort of the baseline. So let me ask Larry, in terms of the Civil Rights Act of 1964, any comments you want to make about that in terms of how it has sort of led the way for many of the things that we take for granted today?
Well, I guess one of my perspectives as a gay American is that we were not included in the Civil Rights Act, and although we were inspired by it, our struggle continued in our own set of uprisings and demonstrations in the Stonewall. And so I guess I wasn't there at that signing, so I don't know, but I imagine people were generally happy to see progress, but it takes time for progress to reach through, and I don't want to say down to other people, I want to see it reach across to other Americans. So I guess that's my perspective is I'm glad to see that it was passed and the statutes gave something. I think Dr. King once said that a law can't keep a man from can't make him love him, but it can keep him from hanging him, and that's a good start. That's a help.
Start, yeah.
So laws do matter, and the example of laws matter.
And I talk about the Civil Rights Act of 1964 as sort of being a baseline. If we go to slide 10, slide 10 is basically a slide that shows us Title IX. And Title IX is a 1972 amendment to the Civil Rights Act. The amendment adds that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. This law enables all the young women here today to be able to compete in athletics and in education on an equal basis with young men at all educational institutions that receive federal funds. For example, all schools that receive government benefits must have equal opportunities for girls and women. Now, the impact of Title IX isn't so much athletics. I once asked someone who was in law school with me when we went over Title IX what the most significant impact of Title IX was where he went to school. He said, one day when I went to school the following semester, there were a bunch of girls in my class. And that was the biggest impact. The impact was educational opportunities being equal. Many of the women lawyers and judges, many of our women doctors and PhDs, all received benefits from Title IX. And so the biggest impact of Title IX has not been in athletics, but in the number of women who have been able to seek careers in previously closed off careers such as law, engineering, and medicine. So I'll ask Jackie, in terms of the impact of Title IX as far as women in previously non-traditional careers, any comments you'd like to make?
I would say that given the time I was graduating from college was about the time of Title IX. And for the first time, there were so many women in law school. It was just amazing. And in the law school that I went to, and in the law schools in the area. And they were not used to a lot of things that women bring with them. For instance, I was married at the time, and I was pregnant. And so they thought I should take a year off. And they had this big meeting with all the deans and everything because I received this fellowship. And they said, well, we just want to let you know that it's okay if you want to take a year off. You're not going to lose your fellowship. And I said, take a year off for what? This is during the Vietnamese War, too. I mean, people were like squatting in rice paddies having babies. So I said, I don't think there's anything wrong with me. I think it's a normal thing that happens to women. And I'm not sick, so they said, oh, they felt very embarrassed. And then they had to, so they withdrew that offer. And I went on and completed my law school all the time. But it did get to be a little troublesome because I was the first woman to be pregnant and go to law school at Boston University. And Boston University's been around a long time.
Yeah. So that takes us to slide 11, which is the first legend that we're going to acknowledge in our path to unity, Florida legend, and that is attorney Anna Brenner Myers. Anna Myers was born in 1896 in Poland and immigrated to the United States as an infant. She graduated high school at the age of 16, during a time when women faced societal pressure to become only teachers or nurses. Myers did both. She worked as a registered nurse, public school teacher, and a social worker in New York. In 1925, she became a citizen at the age of 29 and attended Brooklyn Law School. Myers was admitted to the New York State Bar in 1934 and worked in private practice until moving to Florida in 1936. Myers was admitted to the Florida Bar in 1936. She and her husband owned a bottle gas company in Miami. When he passed away in 1939, Myers took over operations of the company in addition to her law practice. Go to slide 12. As a member of the Dade County School Board in 1953 and a former public school teacher, Myers fought fiercely for the desegregation of public schools and increased wages for teachers. She helped establish the Miami-Dade Community College, Baker Aviation School, and educational television for at-home learning. Myers ran for circuit judge in 1950, but did not win the election. Myers practiced in private practice until her retirement in 1978. Around this time, women nationally made up only 3% of the legal profession, and gender bias was not a recognized legal concept. As an attorney and activist, Myers was passionate about creating positive change in her community and making education accessible to everyone. She was also determined to improve gender equality in the legal profession. As of 2017, women represented 39% of Florida judges, up from 28.8% in 2007. On June 30th, 1951, Myers presided at the luncheon of the founding convention of the Florida Association of Women Lawyers, an organization of women attorneys dedicated to promoting gender equality and leadership roles in the legal profession, judiciary, and community at large. She served as Fall's first president from 1951 to 1952. While gender bias is now recognized as a concept, we still have much to do to achieve true equality. Thankfully, we can rely on the groundwork laid by trailblazers like Anna Brenner Myers. Myers was born in a year when women were not yet given the right to vote, yet she left behind a legacy far greater than anyone could have imagined. She utilized her experience as a public school teacher, nurse, and social worker, and worked as a lawyer to create positive change for women in the public education system. Today, thanks to the efforts of trailblazers like Myers, women make up 36% of the legal profession and 51% of the first-year law students. And I might add, as an aside, in the circuit that I serve in the 12th Judicial Circuit, Manatee, Sarasota, and DeSoto County, women make up the majority of the judges in our circuit. Title IX was passed almost at the end of Myers' career, but is a reflection of the hard work and dedication that trailblazers like her were able to accomplish. So I'm going to ask Larry, do you have any comments about Anna Myers, or looking back on her life, any comments you'd like to make?
I think the thing that stands out is her organizational ability to take an idea and to go with it. One of the things you said, though, that struck me, and it always strikes me when this term is used, that women were given the right to vote. And I believe that when an American takes their first breath on this earth, they are endowed by their Creator and their Constitution with every right of every other person. They should not have to be given anything else. It was taken from women. It was withheld from women. It wasn't then a gift to women. So that always just strikes me that it's very common when we use that. So despite that, her story as trying to be a judge, and she was remarkable, by the way, in terms of her donation of her time and effort in the educational communities and things that she did. But organizing women was the smartest, more powerful, most lasting gift that she could have given. And so she is a great example.
And Jackie, as an African American and a woman, but strictly from a woman's perspective, because certainly at the time that you began your legal career, and beginning your legal career in a male-dominated criminal defense perspective, because you worked, I believe, initially at the Public Defender's Office in Oakland.
Yes.
That, without going into horror stories,
well, that's the fun part.
Looking back on the difficulties that Anna Myers, certainly you can relate to the acceptance of a woman in what up until that point was probably a typically male profession.
Correct. And when I started practicing criminal defense law in California, it was still a male-dominated profession, as was the bench. Not only was it male-dominated, but the vast majority of the judges were Caucasian and had never really even seen a black female lawyer. So you go into the courtroom and you pass through the bar to go where the lawyers sit, and inevitably someone would ask me if I was a court reporter, or as if I didn't know what I was doing, and I would be highly insulted, as a member of the bar. And it was not easy. It was very difficult. It was very difficult picking a jury. But once you picked a jury, you realize the gift to lawyers that jury trials have, and you would never want to give up the right to a jury trial. And so I was able to win quite a few cases.
I think, if I might add, I think this is how much of that still continues. We hope it is less. I happen to be the proud father of 2 daughters, one of whom is a member of the Florida Bar. And I remember her telling the stories of going and getting to the bar, the swinging gate, and
Right.
the bailiff stopping her. And this was 15, maybe 12 years ago, stopping her and saying, "Sorry, ma'am, this is just for lawyers." And she was like, "I know." No, you don't understand. The only lawyers can go through here. I know. And they finally got understood that she wouldn't even tell them she was a lawyer. She just let them just kind of hang in the air. But I hear stories now that I know it still goes on, and
It does.
the remarkable efforts help,
Well,
but it is a constant thing.
It does, and before we go to the next slide, I do want to let people know, as a judge, I am sensitive to how women are treated in front of me because of my sister. And one of the things that I have noticed, I'm going to ask my sister to comment very briefly, is the double standard, especially with litigators. Because we know that when men are aggressive in the courtroom, when they aggressively go after a witness, the same description of what's going on in the courtroom is very different than when a woman does that. And so women are seen differently when they aggressively go after witnesses and things of that nature. And I wondered, in your career, did you have to encounter that, and how did you deal with that?
Well, I realized that you have to be aggressive if you're going to win a case. You can't be passive. I wasn't imitating the men. I was advocating for my clients, and it required me to be aggressive. Because people get on the stands and they tell lies. And so you have to catch them in the lie. And one thing about practicing criminal law, and then I'll stop, is I find I really enjoyed my half of my legal career being a criminal defense attorney. I still believe that it's a profession for young lawyers, because you have to have really quick instincts. You have to be able to think on your feet. You have to be able to remember everything that happened. And it's quite an experience. And yes, being aggressive was fine.
And so in terms of our own judicial training, we have to train ourselves that we have to put any previous stereotypical ideas about how we think women should behave in front of us. We have to separate that. Some judges have an easier problem than others. I grew up with aggressive women. So it was not a big deal to me in the courtroom to see aggressive cross-examination by women attorneys. But for some judges, it's a little bit more difficult. That being said, let's move on to slide 13. Slide 13, this is Judge Mario Goodrich, and I hope I am pronouncing his name correctly. If not, please forgive me. Goderich. Judge Goderich was born in Cuba in approximately 1930. He immigrated to the United States and attended high school in Virginia. And with the encouragement of his parents, who sought the best education for him, he returned to Cuba after graduating high school and attended the University of Havana School of Law, where he received his Doctor of Civil Laws degree in 1957. Gutierrez opened his own law firm called Castellanos and Gutierrez in Cuba, but he was forced to return to the United States in 1961 to escape persecution under the new Castro regime. And back in the United States, he had to start all over and enrolled at the University of Miami School of Law, where he received his Juris Doctorate in 1966. However, he could not be admitted to the Florida bar because of his citizenship status and was forced to take non-legal jobs for 3 more years, including working as a law librarian, eventually working his way up to a law professor at the University of Miami while going through the painstakingly slow naturalization process. In 1969, he was granted American citizenship and admitted to the Florida bar. Quick to help others, the future Judge Gutierrez helped found the Cuban American Bar Association in 1974 and was its first president. Judge Gutierrez became the first Hispanic American to serve as judge of industrial claims when appointed by Governor Reuben Askew in 1975. Judge Gutierrez again became a first when he was appointed as judge in the 11th Judicial Circuit. He was reelected in 1980 and in 1986 without opposition. He became the first Latino to sit on any court of appeal in the United States when he was promoted to the 3rd District Court of Appeal by Governor Bob Martinez in 1990. He received numerous awards, Lawyer of the Americas Award by the University of Miami Inter-American Law Review. Also, the Republic of Colombia bestowed upon him the Order of Democracy. He was the first recipient of the Francisco Garcia Amador Award, presented by the Center for Hispanic and Caribbean Legal Studies at the University of Miami Law School in 1997. He was honored in 2004 with the St. Thomas University School of Law Jurist of the Year Award, and by creation of the Cuban American Bar Association Merit Scholarship, it was named in his honor at Florida International University. Judge Gutierrez concluded his legal career in 2005 upon reaching mandatory retirement age. Let's go to slide 15.
May I
Yes.
just say that Judge Gutierrez passed after being recognized as one of the 5 legends. He had retired, and so of the 5 people represented in the Path to Unity program, 3 are no longer with us. But he was a transition, and I'm sorry that he could not be here to participate.
Yes, and the portrait that will be shown hopefully will rekindle all of the great memories and inspire another generation of Hispanic and Latino lawyers and judges.
I do remember that when Ray, what's Ray's? I'm losing my mind. Ray Aberdeen, when he was interviewed, when he became president, he talked about how he and his generation stood on the shoulders, of people, of lawyers like Judge Gutierrez, that set the example, that started CABA, that encouraged them to do things. So you could see it play out in people's lives, and that's the marvelous thing.
Absolutely.
Sorry, Ray.
So slide 15
I'll call you later.
is an example of a group of Americans who directly benefited from the Civil Rights Movement. And the American with Disabilities Act, again, if you took the Civil Rights Act of 1964 and if it was a tree, this would be a branch of that tree, which is the Americans with Disabilities Act. The ADA, which it's also known as, was signed into law on July 26, 1990 by President George H.W. Bush. It is one of America's most comprehensive pieces of civil rights legislation that prohibits discrimination and guarantees that people with disabilities have the same opportunity, and makes certain that people with disabilities have the same opportunities as everyone else to participate in mainstream of American life, to enjoy employment opportunities, to purchase goods and services, and to participate in state and local government programs and services. Modeled after the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, sex, or national origin. Section 504 of the Rehabilitation Act of 1973, the ADA is an equal opportunity law for people with disabilities. To be protected by the ADA, one must have a disability, which is defined by the ADA as a physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment. This law prohibits discrimination based upon disabilities and mandates that public spaces, including schools, make reasonable accommodation for those who have disabilities. So I'll start with Jackie. Any thoughts about the impact of the ADA and your impressions?
I think it's a wonderful act, and it has brought about, I think, some substantial change in the way that people who have disabilities have been treated. And if you just walk around and see the sidewalks where now you have ramps so people who have wheelchairs can get on the sidewalk, and the federal government, as you know, had a policy of hiring people with handicaps, and did a very good job of doing that. And we both have personal knowledge about that. And so I think it was an excellent act.
Larry, any thoughts about the ADA?
Just that it helped move the needle forward in terms of giving people equal opportunities. People may have differing abilities, but they should have equal opportunities to pursue the lives, the careers, the professions, access to public structures and buildings and parks and education and so many things. So again, it was a remarkably evolutionary act, and to get it passed was a great thing. And Mr. Craft is well known for his acts in Florida, helping especially, you may have said this and maybe I dozed off, but I think he graduated from Harvard, and then Harvard Law School. He is visually impaired, and he got through by his wife reading to him. That was the accommodation at Harvard. The wife read to him, and so he had a special affinity helping citizens who were impaired, to help blind citizens vote, to help people be able to navigate into public buildings and things like that. So just a remarkable story, a remarkable catalyst that brought that act to life. He gave it breath.
And speaking of Attorney Craft, is it Craft? That's how I pronounce it, Craft.
I call him Jim. I don't know.
There he is, slide 16. He is another Florida legend that we are celebrating and recognizing. Attorney Craft has been blind since birth, yet never perceived being blind as a disability. Instead, he simply embraced it as part of who he is. He attended Harvard College and graduated in 1972. And Harvard did not have accessibility standards in place during his attendance. And as you noted, his wife read to him and performed all of his note-taking. And this was well before the ADA was passed. So with the help of his wife, he went on to attend and graduate from Harvard Law School in 1975. Nevertheless, despite excellent grades and working hard, he was unable to attain a position because of his blindness. This compelled him to face the meaning and impact of discrimination and unfair treatment. And if we could go to slide 17. Despite graduating from one of the most prestigious law schools in the United States, he received countless rejection letters and insults from various employers and people. Several years after graduating law school, Attorney Craft was finally able to get a job at the prosecutor's office in Dade County. He was one of the first blind lawyers in the country. He, along with other attorneys, solved countless accommodation problems, accessibility issues, and addressed discrimination against people with disabilities. He remained at the prosecutor's office for over 30 years, where he worked his way up to become one of the lead attorneys. He also served as counsel to the county's Fair Housing and Employment Appeals Board He was tasked with handling complaints in housing based on race, religion, gender, sexual orientation, and disability. One primary problem with people with disabilities face is accessible voting. Crack spent most of his adult life advocating to make voting more accessible and easier for people with disabilities. He fought hard for those with disabilities to have absentee ballots, voting by mail, and accessible voting machines. Why does that sound so familiar now?
Sorry.
In 2000, he had a life-changing experience that pushed him to fight even harder for people with disabilities. That year, he was asked not to go to his usual voting precinct, but instead use a different precinct in town due to his disability. Crack complied and went to the other precinct. Because he is blind, by state law, he is entitled to 2 poll worker witnesses. That day, only 1 worker was assigned, so he asked for a second poll worker. At that point, the assigned poll worker took offense and screamed across a lobby filled with more than 200 people, "He wants another person. He doesn't trust me." Crack describes this experience as one of the most embarrassing experiences of his life, but it turned him into a true voting advocate for accessible voting for people who are blind. After that experience, he fought tirelessly for accessible voting machines in every Florida precinct. In 2002, he succeeded after a law he supported directed state officials to work with county election supervisors to acquire accessible voting machines in every Florida voting precinct. Crack and others were tasked with developing procedures that would allow all voters to cast a secret, independent, and verifiable ballot. In 2019, legislation was passed that allowed for the certification and use of 2 accessible optical scans systems in Florida. He also worked on vote-by-mail ballots for those with disabilities, and he and his team determined that vote-by-mail needed to be an option for voters who are blind so they could vote without the assistance of another person. He also worked with vendors of accessibility software programs to develop absentee vote-by-mail software. This software allows voters to vote at home, privately, and independently using their computer with its screen reader or other access technology, and then print and mail their marked ballots back to the election officials. After years of countless phone calls, meetings, writing letters, and litigation, on the 30th anniversary of the adoption of the ADA, an agreement was reached. 5 Florida counties provided accessible vote-by-mail for the November 2020 election. All Florida counties will provide accessible vote-by-mail by March 2022. There will be a statewide task force to implement procedures and regulations applicable to accessible vote-by-mail in Florida. Crack's work on voting rights and accessibility has been rooted in his strong desire to assure equality for all voters. He is still living. He and his wife live a life in South Florida, a good life in South Florida. He has 2 children and 3 grandchildren. He enjoys serving as a mentor to young attorneys, especially those with disabilities. He constantly reminds the younger generation that as you set out to advocate, remember the fundamental principles. Educate your target audience, build relationships, coalitions, and a team. Maintain a positive attitude, determination, and passion. Use creativity and revolving strategies, and always exhibit persistence, perseverance, and repetition. This will help make your advocacy efforts meaningful and successful. So Larry, any last comments?
No, I wish I'd kept my mouth shut.
Jackie, any comments?
No.
All right. Okay, let's go to slide 18. Slide 18 is a visual representation of equality under the law, LGBTQ rights. In recent years and timeliness, up until today, the Supreme Court has decided a number of important cases recognizing the rights of LGBTQ Americans. These cases include the Lawrence case in 2003, declaring unconstitutional any state law which makes being gay a crime. Obergefell, recognizing an equal right of marriage for same-sex couples, and Bostock, decided in 2020, ensuring that the Civil Rights Act of 1964 protects LGBTQ Americans against discrimination in employment. Also see Fulton, a 2021 case holding under the First Amendment that the city of Philadelphia could not punish a Catholic charity by refusing contracts with it on the basis that the charity refuses adoptions by same-sex couples. The fight for equality for LGBTQ Americans has also taken place among the lawyers of the Florida Bar. So before we get into our next honoree, Larry, what comments would you like to make, especially in light of many things that are being decided even today at the Supreme Court?
Well, I'm sorry that I find myself having to comment every time the Supreme Court gets together. I have to see how many rights I'm going to keep or lose. I'm sorry that my fellow citizens think that my life needs to be voted on. I'm sorry that we need a group of people to get together and tell them that the Constitution, written more than 200 years, that promised equality for everybody, inalienable rights, among them the pursuit of life, liberty, and the pursuit of happiness. We have to revisit that every year. And we did yesterday. There was oral argument in the Supreme Court with many legal commentators speculating that the Supreme Court will carve out an exemption to the Obergefell, to some of the rights, not just Obergefell, but some of the rights that have been promulgated. As a gay American, when the Supreme Court, we wait until June. We've had a number of opinions. Many of these opinions were issued in June, so the summer is a great time for us sometimes, but maybe not every year. And that's the sad thing, is we can never count on anything. Also, I think today, the U.S. House passed the Respect for Marriage Act, which has passed the Senate. It will now go to the United States, the President of the United States, who has said that he will sign it. It will afford some protection. It will not force states to offer marriage equality, but it will require that states recognize marriage equality, so that, if you're married in another state. I'm divorced now, but I was married to a wonderful guy for 25 years, and I remember when we decided, I think it was year 14 or 15, after a holy commitment ceremony, because we couldn't get married. We couldn't decide whether to get married. If you get married in the park, everybody tries to figure out which one's the bride, all that kind of stuff. So we didn't want any of that. But we got on a plane in Orlando, Florida. At that time, there were no rights recognized in state or federal law. But Orlando had created a domestic partner registry where we could go down to City Hall and we could get in if one of us was in the hospital or to claim the other person's body. That was about it. It wasn't much, but it was something. It was more than, because otherwise we had the same legal rights that I had a contract with my housekeeper. That was the legal rights that we had after 10 or 14 years. We got on a plane and we went to, I'm sorry, this is a long story, but it's a good story. And we went to Boston, and we got married. And the judge there said one of the two happiest things she gets to do is to marry people and adopt children, right? So it was a happy time. So we had every right under the laws of the Commonwealth of Massachusetts. From there, we got on a train and we went to New York City, where I was speaking about diversity and inclusion. And at that time, New York wasn't performing same-sex ceremonies, but they would recognize same-sex ceremonies from a different state under the full faith and credit clause of the United States Constitution. And that was kind of fun. And then we got on a plane and we went back to Orlando. So in the course of about 4 days, I was nothing. I was fully married. I was recognized, and I was home back to nothing. So it was a whirlwind romantic experience. But to say that this cycle of never knowing where, it depends on where you park your U-Haul as to whether you're married, whether what rights you have as citizens, and that cannot be right. I can't convince a 5-year-old child that makes any sense, much less a lawyer or a politician. But that's where we are. So that's my thoughts about it. We just have to keep working at it.
And it is the perfect segue as we go to the end of our program and our last acknowledged honoree, slide 19, and he looks very familiar. Attorney Larry Smith. So I'm going to read to you a little bit about Attorney Smith, but then I'm going to sort of, since we have the advantage of having him here, I'm going to have him sort of help wrap up what we're doing here. But let me just read a few things. Larry Smith is another living legend. He grew up in a family of modest means in rural Alabama. His parents only had a 6th grade level of education, and the house he grew up in had no running water. But Larry had big dreams, and he knew he wanted to work hard and pursue higher education. In 1979, Larry graduated from the University of North Alabama, becoming the first member of his family to graduate from college. For 2 years after graduation, he worked to save money and entered law school at the University of Alabama in 1981. Also in 1981, the Florida Supreme Court begrudgingly decided that members of the LGBTQ plus community could be admitted to the Florida bar. In 1999, Larry read an article in the Florida Bar News featuring Justice Harry Lee Anstead addressing professionalism and diversity. Justice Anstead noted that diversity was an integral part of professionalism and that race, gender, and ethnicity were areas where the Florida bar needed to improve. Larry wrote a long, fact-filled letter to Justice Anstead,
Imagine.
challenging him to include sexual orientation in the Florida bar's diversity efforts. It was the first time Larry can remember writing to any public figure about an LGBTQ plus issue, an issue he personally identified with. Justice Anstead reached out to Larry and challenged him back. Quote, "If you want to be part of the solution, I'll walk down the hall and ask the Chief Justice to appoint you to the Supreme Court Commission on Professionalism. If not, it was a really good letter." Larry was worried about what his firm, colleagues, and clients would think about him being openly gay. But Larry decided he would become part of the solution, a mindset he would continue throughout his entire career. Larry became the first openly gay member of the Florida Supreme Court Commission on Professionalism, the first openly gay attorney to address Florida attorneys about professionalism and diversity that included the LGBTQ community, the first openly gay person to sit on a number of important substantive law committees, and a powerful voice and example of the LGBTQ legal community on a state and national level. In addition to his 30-plus years as a distinguished litigator, Larry has received numerous awards for his work in diversity, equity, and inclusion, including the 2002 Watermark's Central Florida Co-Person of the Year for his work on equal employment, housing, and public accommodations for Orlando's LGBTQ plus citizens, the 2013 ABA Section of Litigation's Diversity Leadership Award, the 2013 Florida Bar's Henry Latimer Diversity Award, the 2013-2015 Defense Research Institute Cheryl J. Willard Diversity Pioneer Award, Litigation Council of America's Peter Perlman Service Award, which recognized those who meaningfully contribute to society by giving back their time and resources in an effort to improve the lives of others, the 2016 Florida Bar Young Lawyers Division Diversity Award, the 2016 Florida Bar G. Kirk Haas Humanitarian Award. In 2020, Larry founded the Veriosity Institute for Inclusive Excellence, an organization focused on helping law firms and businesses achieve their own inclusive excellence, which recognizes the value of the individual, the contributions of a diverse workforce, and the improved work product which comes from inclusivity. Larry recently celebrated his 24th anniversary with his partner Clayton. I'm not sure that date's accurate now.
Well, I did celebrate it.
Okay, well,
I remember.
they are proud parents of 2 adult daughters and the grandparents of a very special little grandson. Larry is a real-life example that no matter how humble one's start is, no matter the obstacles or obstructions, no matter the prejudice or pain, armed with knowledge, secure in faith, and sustained by courage, patience, perseverance, and determination, lawyers can change the world. And I'm going to
I didn't
say,
write that.
there's even more that I would like to say about your dedication to diversity and inclusion, but at this time, I'm going to turn it over to you to not only comment about the Path to Unity as a whole, but your experience as it relates to what we've been talking here today. So I'll end with you, Larry.
Thank you. First, I want to thank the organizers for continuing the Path to Unity, which is a wonderful, marvelous brainchild of Charlie Ann Seipert and the entire Diversity and Inclusion Committee of the Florida Bar. It is a multi-year project filled with challenge of a pandemic, multiple hurricanes, and so I think this program has been rescheduled a couple of times, but it continues to give life, as I said before, to give life to things. I also want to thank Judge Williams, who not only did a great job here going through this incredible history, and especially the history here in this community, because, you know, what they say, all politics are local, a lot of pain is local, a lot of experience is local, and I can feel it when I hear the stories. But also the Path to Unity program that's going through the educational components, that's going through middle and high schools, so that kids get to hear that things can change. They get to hear we're losing people, we're losing the memory of the challenge that people have faced to change the world. So I guess what I want to do in a short period of time, which is so difficult for a trial lawyer to do, but I want to talk about my favorite subject, which is me. Not really, but I have to. So, but I'll try to put that in context a little bit. And first, as you can see, I have some written remarks. First of all, if you're going to talk about yourself and you're going to make up stuff, you have to write it down so you don't forget it. And secondly, this is a wonderful CLE presentation, and they're more likely to give us more credit if I look like I wrote something down. So there it is. In all seriousness, I really feel woefully humbled when I hear the other people that are being recognized. I am apologetic that we could not find somebody better than me, but here I am, and I'm just going to do the best I can. I always have a little bit of a pit in my stomach when I talk about stuff like this, because I think people expect, you know, you get a portrait and you get all these awards and they think you're just going to have something remarkable to say, and I'm not a very remarkable person, but I thought maybe if there was a takeaway today, the comments is that you don't have to be a remarkable person for remarkable things to happen. So you heard I didn't come from a place where I knew lawyers. I didn't have dinner with judges or anything like that. My experience with Justice Anstead was basically, I just felt from an integrity standpoint, I was kind of out at work, but that wasn't the point either. I just thought, I have my name on a door, I've got enough money, I can eat if they fire me. I want to make my kids proud of me, and I want them to be who they should be, and if I lie and I hide behind a mask, how will they ever feel like they can do? And that's my role as a parent. So I wrote him this really long letter, and you heard the story of, he was very gracious. He called me, and when he called me, you know, I'd kind of forgotten about the letter. You know, it was a very cathartic moment to write it. And then when he called, I'm thinking, dear God, what have I done? You know, should I snatch my diploma off the wall and run with it? How far can they find me? But he was entirely gracious, and he told his own story of growing up Jewish in Jacksonville and some anti-Semitism. And that's when he said, I don't understand your story, but I understand you have a story. And if you want to tell that story, I'll walk down the hall. Well, first of all, I was just glad I wasn't going to lose my license. And I'd never talked to a Supreme Court justice in my life. And so I wasn't about to tell him no. I was just going to be nice and play good. So I do want to add a story if I have time. I hope I do. So I go to this first meeting. He appoints me to, the Chief Justice appoints me to the Supreme Court Commission, and I go. And I swear, you know me, I'm quiet, right? I'm going to go. I've got on my best trial suit, you know, I've got on the cufflinks. I've got everything. I may have wore a red tie to fool them. I'm not sure. But I was there, and I was going to be the quietest, good little doobie in the whole room, and they were going to get to know me, and they were going to get to like me, and I was going to put my shoulder to the wheel. And, a year or so later, they would say, well, what are you doing? And I might say, man, my partner and I are going to whatever. That was my plan. So Justice Periente was the liaison, and I'm sitting at my table very quietly, and she does the same thing. We're here, we're talking about, race, gender, ethnicity, and she probably almost got to a comma, but not to a period or a semicolon. So the arm goes with the cup link, looks like a disco ball catching the light up in the air. Excuse me. And I told her, if we're here to work for everybody, I will be the first one in the line. When you need something, I will be the first one in line. I will be the last one to leave. My shoulder will be bruised before anybody's shoulder against that wheel. But if we're not, I'm in the wrong room, right? So, no. She said, oh, no. We're here for everybody. We're here for everybody, Larry. Calm yourself down. And that was the first hug I got from a Supreme Court justice. Not the last, but it was the first hug I got. And so we got through that, and everybody. It was really my first outing of myself too. And there's nothing quite like gay people go through outing. Every time we meet somebody, we have to out ourselves. Hi. How are you? Well, I'm gay. How are you? Almost, right? Not quite, but almost. So to do it in a public way that I didn't have a choice. I knew I did not have a choice. I don't say that lightly. I could not breathe if I didn't say the truth, if I did not speak the truth. And so that leads me to an experience. I won't tell about all my experiences. One of the time you don't have the interest. But one of the first things, in talking about being the first to address the Florida bar, it was a master's in professionalism. They asked me to be on the panel because by then I think they thought I was going to be on it anyway. I was just going to walk in and do it. They gave me a given amount of time. We were on a panel like we are here, and they told me how much time I had. So I had my remarks ready because I am a prepared trial lawyer, right? We may veer from the outline, but we have an outline. So again, and I'm going through it, and then they start talking just before it becomes my turn that we're running short of time. And could you cut yours short? And I'm like, no. I may never speak again. I may not have a license after this afternoon. But my people will be heard. They have never been heard. They will be heard no matter what. You cut it somewhere else. And I just start talking. The Chief Justice, who was a very fine moderator, by the way, but did not exercise quite as much control as he had hoped. He's literally standing in the back of the room giving me the stop, cut it off. I just keep going to the end, and then afterwards I apologized to him, and he said, I understand completely. And so it's all been good. People have been really pretty perceptive. And once they realize you'll talk, they ask you to talk. And as you can tell, I don't mind talking, so I've talked a lot. In terms of becoming a legend, let me just say that when you're young, they call you a pain in the ass. And when you get old, it's sort of like a saint is just a sinner that has died. I think a legend is just somebody that's lived a long time. So that's how I got it. It was by default. I outlived everybody else. I thought it was a real hoot when I read the stuff about this, like Larry Smith, a tireless advocate. Oh, hell no, I'm tired. I am tired. I am here. I am recruiting. I'm recruiting somebody to pick up the torch. And so I hope that's what it will be. Now, I want to comment just a little on the portrait itself, because one component that you might not know when Judge Williams showed you all of those portraits is that partially through Charlie Ann's incredible artistic lent and her connections, these paintings were all painted by, 4 of the 5 were painted, all of them painted by Florida artists, students. 4 of them at the Ringling School of Art. But what you might know is that and to further sort of understand the perspective of the people they were painting, the students applied, but there was an opportunity to pair so that a young woman painted the painting of the woman. A young African-American artist painted the painting of James Weldon Johnson. And a young gay man painted my portrait. And Oliver Stevenson was his name, and he interviewed me over a Zoom call, right, a conference. This was during COVID, right, so we're talking on that, and I said, okay, now let's just cut to the chase. I know you don't have much to work with. I don't care what I look like, obviously. I don't care what I look like. There is only one thing that matters. You have one job, and I have one job, and that is when people pass this portrait, when they walk past it, that we make them understand why there's even a portrait. Not who's in the portrait, but why there's a portrait. And we came up with the rainbow ribbon that I'm wearing, the same ribbon that I'm wearing there. So we wanted to make people stop and think. Recently, and I'm just about through, Judge, before you knock me off this chair, but I was interviewed recently, and I was asked, after they read all of that stuff about me too, and they said, what would you like your legacy to be in diversity? And I said, I just want one kid, one student, one want to be a judge or a justice or a lawyer, one citizen who walks by and for one moment feels proud and empowered, who feels that they have a place at that table, that they can be anything they want to be, they smile, and they walk on with the rest of their life. That's what I want. Getting that smile is not that big of a thing. It's not even that most remarkable thing, but it is a thing that is within every one of our grasp to make a difference, to make a change, to find our voice, to do something good. Plus, you might get a painting. I don't know about that, but you may get to change somebody's life. That was the real opportunity out of this for me. Thank you.
Thank you.
Thank you.
I get weepy.
And Starlet, if you could just put it on as we conclude the slide 21, the last slide. I want to thank my panelists, Larry, Jacqueline, for being here. Everyone that has put this on, Starlet, Nancy, thank you so much. Beth, introducing the program, Charlie Ann. You know, this project resonates with me because I'm still the only African-American judge in the 12th Judicial Circuit who's a male. We have an African-American female judge. So the path to unity sort of speaks to my aspirations in that when I first got the position, it was very important that I'm not the last. So I'm hopeful that as the Florida Bar continues this journey, that it inspires other people as it inspires people who will hear your story and my sister's story and the story of the other people we have celebrated to continue the good fight and to certainly make America and Florida as inclusive as possible. So thank you all for being here, and we conclude.
It's happy hour.
Right on time.
I can't do that. Don't forget
That was true. I so enjoyed hearing their story. Of course, yours too. But
The one message that I want this program to convey, and you really.
You want to go on tape?
Oh, well, why don't you?
Yeah.
Charlie Ann. Oh, I wish.
Yeah, why don't you? No, come on.
Charlie Ann.
No, go up to the lectern.
Oh, God.
And our,
The one, and you, Larry, you really addressed this at the very end, but this program, the whole motivation for creating this program was to inspire the next generation of lawyers and to empower them with the idea that we can affect change. And if you listen to Judge Williams' presentation of the historical timeline, every significant change in our society happened as a result of work by lawyers. So that's a big responsibility to place on the shoulders of young lawyers. And my fear as when I assumed the role of chair of the diversity committee, was I saw young lawyers becoming satisfied almost. You know, like the work has been done. It's not done. In fact, it's being undone more recently. So what I hope this program will achieve as we take it to middle schools and high schools is it will remind them that we fought hard. I mean, it wasn't easy, Jackie being a woman when we first got out of law school. It was pretty gosh darn hard. But it'll inspire them to pick, as you said, pick up the torch and continue our fight. Sadly, we do have to fight. And they can go on and achieve great things. I have a granddaughter who is a sophomore in college, and she's met with Judge Williams, and she's very familiar with this program. And she's now picking up the torch. And like your daughter, Jen, who is doing it so boldly and brilliantly, that's what our goal was with this program, is to prepare and give birth to a new generation of fighters and leaders. So thank you, Larry, and thank you to Judge Williams for being such an inspiration to so many young lawyers, and Jackie, you too. By the way, Jackie and I were both lawyers in Virgin Islands around the same time, so, and I don't know if you all know this, Charles and I practiced together in the PD's office, and then we had our own private practice, so we're like family here. You know, so thank you, everybody.
Thank you.
Thank you.
Okay. All right.
The judge says we're adjourned, so
You
we're
are
adjourned.
adjourned. You're officially adjourned.
Now, we hope to reach anyone who's interested in history and the law, anyone who's interested in being a judge, being a lawyer, working in the legal profession, students who are interested in our government, people who are interested in our Constitution and understanding what it takes to make a country what it is today. So we just hope to educate people about not only what's unique about the law and lawyers, but what's unique about Florida law and lawyers. So hopefully this Path to Unity project will work towards that.
The message that I hope is conveyed and will resonate with the young people who participate in this program is that they'll see how noble and how powerful the legal profession is, and that they will feel empowered to pursue law school and a career in law. Because if you look back in history, all the significant change came about by lawyers. We are change makers. And as I said, we want to inspire the next generation of young lawyers to pick up the torch and continue the fight that the legends that we showcase in this program began for all of us. There has actually been studies that examined pipeline programs throughout the nation by the ABA, and it's never too late, and it's never too soon. And they actually found that teaching these sorts of lessons that are contained in the Path to Unity project to grade school and middle school kids, because that's where you will give birth to a love of history and appreciation of history. And that's when ideas about heroes and heroines are created in the minds of young people. And that will give them a path to pursue in their middle school, high school, and college years. I know for me, seeing a portrait of the first president of the Florida Association for Women Lawyers, it's inspiring, and it's also validating, and it's also comforting to know that all the struggles, and yeah, there were struggles for women my age when we first entered the legal profession. It makes me feel, you know, it was all worth it. We've accomplished something. But I hope that a young person, a young African American, a young gay lawyer, a lawyer with disabilities, a young Latino lawyer, or a young student will look at those portraits and think, yeah, I can do that too.
I've been at the bar for 12 years, into my 12th year, and have been doing this same job. It's been a wonderful experience being the first diversity initiatives manager, being able to work with the Leadership Academy and the Diversity and Inclusion Committee. The committee has approximately 103 individuals on the committee. They're all lawyers, of course, and we do different programs throughout the state. Today we are looking at the Path to Unity project and the 5 legends. The 5 legends represent those individuals who represent five different sectors of the Florida Bar. And we have 5 of the greatest examples ever to be on this side. We have been sharing this program throughout the state, and we will continue to share this program for at least another year. So we're encouraging everyone to come and see the Path to Unity project with our 5 legends.